All right, Wes, it's all you.
All right, let me get started here. All right, does everyone see this? Okay, I'm going to presume everyone does. So I will get started. This is kind of my presentation that I've done over the years. This is an introduction to EMS legal and ethical issues. Like your instructor said, I'm Wes Ogilvie. I'm licensed paramedic in the state of Texas. Also, nationally registered and paramedic in Louisiana. I don't know why I maintained that certification. I just thought it was cool to do. And I'm a licensed attorney in Texas. And I have some standard legal disclaimers because that's what attorneys do. This is not legal advice. Nothing in here is legal advice. If you want legal advice, you should hire a lawyer. I'm not your lawyer. For the right price, I could be your lawyer, although I'm only admitted to practice in the state of Texas. Some other humorous reminders. Some contents may settle during shipping. Close cover before striking. Objects in mirror may be closer than they appear. And if you have read this far, you don't need eyeglasses. And there are bonus points to anyone who knows what movie that last line is in reference to. I'm hoping someone does. Okay. We'll keep moving here. So let's talk about what we're going to cover tonight. We're going to talk about the legal framework of EMS, or what I call, how do we get to do this cool stuff? We're going to talk about criminal, tort, and administrative law. We're going to talk about consent and refusal of care. We're going to talk about confidentiality, including the correct spelling of HIPAA, evidence preservation, statutory responsibilities, mandatory reporting, healthcare regulation, advanced directives, end of life, ethics, morals, and professional standards, patient rights and advocacy, ethical tests and decision making, and employment and labor law, which I think is actually one of the most overlooked things in EMS. I'll also note that this presentation is something I've been doing for years. A lot of it has a lot of references to Texas, but I did cover all the national standards in here. So the Texas stuff you can just ignore because you're not in the best state in the country. I do have some serious disclaimers here. Most legal issues are incredibly dependent on the facts. Each state has a different set of laws and regulations, including those related to the practice of EMS. The ultimate decider of what the facts are is typically the jury. The application of the law and how the law applies is decided by a judge. As a note, only appellate case decisions applicable to your jurisdiction create binding law, along with statutes and regulations. And the reason I point that out, how many of y'all participate in EMS social media? I can't get a show of hands because I can't see you, but if I was in the classroom, I know I'd get a couple of people. And what happens is about once every couple months, there's an article about someone got sued for something involving EMS somehow. And it's happened somewhere, and everyone goes, oh my God, this is terrible, this is horrendous. And it's a lawsuit that hadn't been decided yet, usually. It's usually a story about the lawsuit being filed, and it's in another state, so it probably doesn't apply to you. And that brings up the other thing. The overwhelming majority of law relating to EMS is at the state, not the federal level. What EMS providers of all levels, anything from your first responder all the way up to your flight nurse and flight paramedic, or using the Pennsylvania term, pre-hospital registered nurse. I believe there's, correct me if I'm wrong, I think there's also a special license for pre-hospital physician assistant. For what we all do is consider the practice of medicine in some format. Therefore, we have to have a legal mechanism for us to practice medicine. Every state, including my home state of Texas, has laws governing the practice of EMS. Our laws, well, and you've got those are just cool to know, but excuse me, I promise that's not a COVID cough. Our state laws and regulations are there for Texas. I did not have the chance to research Pennsylvania, and I would be very hesitant to research Pennsylvania because I don't know Pennsylvania law. I'm pretty sure murder's illegal in Pennsylvania. I know murder's illegal in Texas unless they really needed killing, but that's another story. And then you also have to have medical direction. There's delegated practice versus scope of practice. Texas is a very unique state. I'm going to mention a little bit about how we do EMS in Texas because it's very unique from other states. I know Pennsylvania has a defined scope of practice and a defined set of state protocols. We don't in Texas. It is whatever your medical director signs off on your service doing, and each service has its own medical director. So there's three kinds of law that apply here. We've got criminal law, which is a statute imposing a penalty, fine, or punishment for certain offenses of public nature or wrongs committed against the state. You know, that's when you think about like your Dragnet and your Law and Order episodes where they talk about, you know, People versus Johnson, State versus Smith. Tort is a tort law is private or civil wrong for which the court will provide a remedy in the form of an action for damages. In other words, and I don't know who advertises on TV in Pennsylvania, but we've got a bunch of attorneys who advertise on TV. If you've been in a wreck and need an attorney, call these guys. My favorite, of course, is out of Las Vegas. There's a guy named Glenn Lerner. In a wreck, get a check. And I can also, I should have thought of this before I did this. I should have put the clip from J.G. Wentworth. It's my money. I need it now. Administrative law is a body of law created by administrative agency in the form of laws, rules, regulations, orders, or decisions to carry out the regulatory powers and duties of such agencies. So for EMS, it might be your state health department has that administrative law. And some acts could be a crime, a tort, and an administrative violation. Criminal law, like I talked about, state versus the defendant. Your penalties can include jail, probation, deferred adjudication, fine. And because anyone in EMS needs to be a Mel Brooks fan because Mel Brooks just is perfect, we have a clip from the best movie of all time.
Wes, there's no audio. What's that?
Still no audio?
No. Unfortunately, that's one of the downfalls with GoToMeeting. It doesn't play it very well.
Well, darn. We have a Mel Brooks clip, and one of the funniest clips of all time from Blazing Saddles. So we'll talk about tort law now. It's also known as civil law. You have, instead of criminal charges, you have a lawsuit. And I don't know if we can unmute people or what, but I'm going to take a volunteer here. We know for criminal law, you have to have probable cause to file charges. What's the standard to file a lawsuit, a civil lawsuit? Does anyone know? I'll take a volunteer. I can't call people because I don't know you.
There has to be damage done.
To file a lawsuit.
Oh, not to file a lawsuit, but to have a successful lawsuit.
Well, to have a successful lawsuit, we got to have that standard of proof, which is usually a preponderance of evidence, which is 50% plus just a smidgen more. What's the standard to file a lawsuit? What's the standard to file a lawsuit? Does anyone have a guess? Going once?
There is no standard. Anybody can file a lawsuit if they want to.
Exactly. Were you able to get to the courthouse, find the clerk's office, and pay the fee? Intentional torts are things that you do intentionally. Negligence are things that happen by mistake. And we're going to talk more about that in a minute. Intentional torts require specific intent. Generally speaking, you can't get your insurance to cover an intentional act. And there's actual damages, i.e. how much the person was harmed, and possibly punitive damages. That's almost like a fine. It's a way of saying, hey, this is really objectionable behavior. The court is going to sanction you for doing that. Negligence, made up of 4 elements: duty, breach, causation, and damages. You got to have all 4 elements. Can't have 3 out of 4. Got to have all 4. And it doesn't require intent. Let's talk about that. When does a duty to act attach? Do we have a duty to act? And what I want to note here is this is a legal duty to act, not necessarily a moral or ethical duty. So when do EMS people have a duty to act? Volunteers? Okay, no volunteers. Who here has heard, and again, I can't see hands being raised, that's kind of a challenge, but who here has heard the story that if you have an EMS sticker on your car, you have to stop at a car wreck? Has anyone here heard that?
Isn't our duty to act only when we're on shift? If we're off of shift, we don't have a duty to act.
Typically speaking, yeah, you only have a duty to act if you're on duty and you're assigned to the call. Now, I know we're going to have people that say, well, you know, and there's going to be all these what ifs because everyone's got a hypothetical, but the duty to act doesn't attach unless you're assigned the call. Now, the one thing I will say is that if you do decide to stop, you've now put yourself in a position where you do have that duty to act, and you have to continue to act until you hand over care to someone else. Breach. You got to breach that duty to the person. And so we have a standard of care. How do we establish a standard of care? And who decides what the standard of care is? Any thoughts from the audience? By the way, I guess Rick didn't tell you, this is a participatory lecture tonight.
I think the standard of care is set partially by, you know, whatever state you're in, because they give you your scope of practice and what you're expected to do in a given circumstance. And I think your agency's policies define that a little bit more specifically.
Okay, so in a lawsuit, that's how we decide, huh?
I think in a lawsuit, they're gonna go back to the state standards. Probably. I don't know.
Are you sure?
I think they would decide what a competent paramedic would do. So what would another competent paramedic do in the same situation?
What would that reasonable paramedic do? That's a good question, and we're getting closer. The reality is that there's a lot of factors that go into it. I'm not going to swing my laptop around because my upstairs bedroom where I'm lecturing from right now is a disaster. I've been working and living out of here while we're on this quarantine thing, but I have a big bookshelf full of medical books, everything from the EMT level all the way up to physician level. And I guarantee you that if you go into trial on one of these things, all those books are going to get pulled in to play everything from, you know, your AHA, BLS for healthcare providers, all the way up to, let's see what I've got down here that y'all might recognize. Harrison's Principles of Internal Medicine, which is what they use to train internal medicine physicians. So, but who decides what that standard of care is when you get to court? Who makes that determination? Who makes the determination of what the standard of care is?
Is it the judge?
Are you sure about that?
I think they might try to call an expert.
They're going to call an expert to help to tell people what they think the standard of care is, but who ultimately decides what that standard of care is in a court case?
The jury.
The jury, or as I like to say, 12 people who couldn't figure out how to get out of jury duty. When I was in law school, I went to law school at Texas Tech University in Lubbock, Texas. I don't know if any of y'all know where Lubbock is, but it's up in the Texas. It's up at the base of the Texas Panhandle, and there's a lot of wide open spaces around there. In fact, if you ever heard that old Dixie Chicks song "Wide Open Spaces," it's about Lubbock. There's a lot of wide open spaces, and there's a lot of small counties around Lubbock. And when I was in law school, a couple of the attorneys who taught at the law school told us every one of those counties has an old guy, probably named Floyd. And Floyd sits on the park bench in front of the county courthouse and talks to the squirrels. And if they get 11 jurors and can't find a 12th one, the joke is that the judge is going to send the deputy sheriff out to go get Floyd. And Floyd's been on the jury a couple times, so he'll be the foreman of the jury. So ultimately, your standard of what the standard of care is may be determined by Floyd, the guy who talks to the squirrels. I'm going to pretend I hear laughter. You can breach that standard of duty by committing an act or by omitting an act. Let's talk about that. So you could do something incorrectly. You could, best example for that at the paramedic level is you could have a failed, you could fail to recognize an esophageal intubation. That's pretty much a bad thing, we know. Or you could forget to do something important. Great example of that might be you don't administer aspirin for chest pain. And abandoning your patient is also considered a breach of the duty to act. Causation. The failure to deliver that standard of care directly caused the injury or illness or the worsening of the condition. That sometimes is hard to prove, especially when you've got, I think we've noticed that sometimes our patients in EMS tend to be a little sick before they called us. Sometimes they have multiple comorbidities. Anyone who's done clinicals at any level has at some point experienced what I call the BOM, bag o' meds. You've got the patient who's got congestive heart failure, chronic obstructive pulmonary disease, diabetes, hypertension, hyperlipidemia, and diabetic neuropathy. So they've got the big bag of meds. So sometimes in these cases, it can be hard to prove that causation. And then you have to have damages. There have to be actual damages to the patient, whether they're physical damages or pain and suffering. And then in some rare cases, we talked about this earlier, there could be punitive damages, particularly for an intentional tort. Other forms of negligence, res ipsa loquitur. Lawyers love Latin, by the way. That's Latin. It translates to the thing speaks for itself. It is an act that is so bad that there's no way it could have happened except for negligence. The example they use in law school is airplanes falling out of the sky. Airplanes don't fall out of the sky for no reason. There's got to be negligence involved. I think for EMS, I think we could argue that an unrecognized esophageal intubation is something that only happens by negligence. We've got so many tools to verify placement of an airway that there's no excuse. And then we have negligence per se. That is, by virtue of you having broken another law, you're deemed to be negligent. The great example that I use is traffic accidents. I don't know how Pennsylvania works with traffic accidents, but in Texas, one of the cops' favorite things to write people for after an accident is basic, and they call it a variety of different things, but it's following too close. And you get your ticket, and it says mail it back to the court. And in Texas, there's 3 options on it. There's not guilty and I request a trial, There's guilty and here's my fine money, or here's my money for driving school. And then there's no contest. It means I'm not saying I'm guilty, but I want to make this go away. Why is that no contest there? Because of negligence per se. Because pleading guilty to violating the law could be an admission of something else. So you will put this back in the EMS standpoint. You you tap someone's rear bumper while you're driving the ambulance. You get the ticket and you say, you know what, God, I did it. I'm going to plead guilty. Well, all of a sudden now that guy who advertises on the guy in Pennsylvania who advertises on TV is going to say, see, look, this EMT or paramedic pled guilty to following too closely. Therefore, they did it. They were negligent. Fences to negligence. Again, a lot of this is very state, actually not a lot. This is all very state dependent. Some states, including Texas, have governmental immunity. That basically means you can't sue the government without their permission. The idea behind that is that ultimately we're the government and that money comes from the taxpayers. Every state has a Good Samaritan Act, and whether or not it covers the EMS is a state-specific question, or to use my favorite phrase as a lawyer, it depends. I've given you the Texas one. Generally speaking, it says that if you're providing emergency care, most states Good Samaritan Act, and we can talk about the Texas one if you really want, because I know about it. But most states, the idea of the Good Samaritan Act is if you're not on duty and you provide emergency care, you're held to a standard of gross negligence, which means you're to be liable, you have to have been really, really negligent. The idea behind this is we want people helping in the event of an emergency. You know, if you're at, and I don't know the restaurants up there, I would use Whataburger, but you guys don't know Whataburger. You should, but that's a different story. But you're up at McDonald's and someone starts choking on a McNugget. We don't want people scared to give the Heimlich maneuver because they're scared of being sued. We want people to give the Heimlich. Therefore, we have a Good Samaritan Act. Statute of limitations is basically gives people a certain amount of time before they can, after which they can no longer sue. And then we've got comparative and contributory negligence. Basically what that means is, did the person who's suing, did they do something that made the situation, that helped create the situation? Protections from liability. Professionalism. Absolutely. Standard of care. Follow your locally established standard of care. How many of you guys have insurance? Does anyone in here have insurance? Feel free to talk if you do. I'm going to tell you why having insurance is a really good idea. First of all, everyone knows that insurance, if you have liability insurance, it means there's a pot of money that if you're found liable, that the insurance company will pay up to that amount of money. Here's the thing that most people don't realize is insurance, because of that, comes with a duty to defend clause. What that means is if you get sued for something that's in the scope of your insurance coverage, your insurance company provides you a lawyer to represent you. I'm going to skip the next one. We're going, oh, what happened here? Oh, I have no idea what happened here. We're going to skip the next one and go to the last one, which is documentation practices. Write a good report. Describe what you did, because I will guarantee you these cases do not come up a week after you ran the call. They come up a year or two, maybe 3, 4, 5 years by the time it gets to court. And all you've got to rely on is your chart. One of the most important things is be nice. There's actually a lot of, what the? I don't know what I've done here, but there's a lot of research out there, and there's actually, I don't have the articles in front of me. There's a lot of research out there that says that healthcare providers who are nice don't get sued. The truth is probably greater than 95% of the people we come into contact with have no idea what EMTs or paramedics do or what they know. They just don't. What they do know is whether or not you were nice and took care of them. So nice people don't get sued as often. Let's talk about consent and refusals. People have to consent. Generally speaking, people have to consent to their care. You guys say what you think's going on with them. Give them your recommendation for treatment. Tell them the risks and benefits of that treatment. Ask for their permission, and maybe even give alternatives. There's a couple types of consent. Express consent. May I start this IV on you? Yes, you may. Informed consent. I would like to give you this medication. It's going to have it may have some side effects, but the benefit is it's going to stop your heart attack from getting worse. You've got implied or incapacitation, whether that person is incapacitated mentally or they're physically incapacitated. Involuntary, people in a mental health situation or maybe incarcerated, they can't give consent, so someone else gives consent for them. Minors, parents give consent. There's a concept called in loco parentis, has nothing to do with crazy parents. That's Karen on Facebook. In loco parentis are people who are acting in place of the parent. The best example I can think of is you're at school, the teacher. You're at the baseball field, the little league coach. They usually have a permission slip. Remember when we were kids and we had to get the permission slip to go on a field trip? This is why. You hear about emancipated minors. Sometimes a minor who's married or in the armed forces may be considered an adult under the law. You can, in some cases, a minor can go to court and be relieved and be determined to be an adult for the purposes of the law, and also pregnancy. At least in Texas, you can only get a minor who's pregnant can only give consent for something relating to the unborn child. Texas consent law, that's Texas Health and Safety Code. We're going to skip over that because we're not in Texas right now. Refusals. An adult with adequate present mental capacity has the right to refuse treatment or transport. The patient may withdraw consent from treatment at any time, and you need to document that present mental capacity objectively. What I like to say is people have the right to make their own bad decisions. We can't substitute our judgment for theirs most of the time. The refusal must be informed and the patient needs to sign a release from liability. When in doubt, it's safest to treat. Documentation is extremely important for this. Many suits are brought from cases where the patient wasn't transported. Contact medical controller supervision, especially if you feel the patient needs treatment or transport but continues to refuse. And refusals of service by medics are an invitation to lawsuit. We always hear stories about EMS telling people, you don't need to go to the hospital, I'm not taking you. That's a real good way to get yourself on the front page of the local newspaper. One of the things I'll also throw in here is that when we talk about refusals, it doesn't have to be a refusal of transport, of treatment and transport. It could be, I don't want to be on the backboard. Well, or you have someone who's having a STEMI, who's having a heart attack, and you say, I want to take you to the hospital with a cath lab. Well, I don't want to go there. I've always gone to such and such hospital because my podiatrist sees me there. So those are examples of when they may be refusing some of the treatment or transport or what you recommend. Still, in those cases, I would recommend getting that signed refusal. I'm going to have you sign here saying that we told you we would like to take you to the big hospital that can take care of you, but you have chosen to go to the little hospital that doesn't have those capabilities. Abandonment. That is termination of care of the patient without their consent and or without assuring continuation of care at the same or higher level of treatment. Some examples of that is you've got a patient who needs ALS care and you have an EMT in the back with the patient while the paramedic drives. I'll tell you a real interesting story about that one in just a second. Or refusing to take a patient to the hospital for evaluation and that patient requires care. I'm not taking you. Sorry, you need to go some other way. We've had some stories about that down here. The story I'll give about the EMT in the back. Years and years ago, there was a case, small town, probably about an hour southeast of where I live, where there was an paramedic and EMT transporting a patient who was having a heart attack. Obviously, we know that patient needs ALS. They need to be on the cardiac monitor. They need an IV. They need medications. Well, it was about 3 or 4 in the morning. EMT says, I'm scared to drive at night. I don't want to drive at night. Well, we got to get the patient to the hospital somehow. So in this case, what they did was they had the EMT get in the back, the paramedic drove, and they hung the cardiac monitor from the back of from the ceiling of the back of the ambulance so the paramedic could monitor it through the rear view mirror. That did not go well for anyone. Medical restraint and use of force. We do it to prevent patients from harming themselves or others. That's the only reason to do it. We can't do it because we don't like someone. We've got 2 methods of restraint. All levels can do physical restraint. Paramedic level, depending on what your protocols and scope of practice is, you may be able to do chemical restraint. How much training have we gotten on physical restraint? Not much. You go in the back of your EMT or paramedic textbook, and there's a couple of really old pictures of EMTs and paramedics wearing really dated uniforms, and they're trying to do these bizarre kung fu moves, and that's about all the training you get. Now, for the paramedic students in the room, how much training do we get on chemical restraint? I'll take a volunteer. How much training do we get on chemical restraint? Anyone? I feel like Ferris Bueller's Day Off. Bueller? Anyone got any thoughts on how much training we get in chemical restraint? Well, let's think about it for a minute. We get training on how to draw up a medication, how to administer a medication, how to monitor a patient, and what those medications do and how they interact with other medications. So we actually get a pretty fair amount of training on chemical restraint. Maybe that's a little safer. Something to think about, y'all. Legal consequences relating to consent. We've talked about abandonment, false imprisonment. That's holding someone against their will. Assault, that's placing someone in fear that you're going to harm them. Battery is the unlawful civil touching of someone. Even if I just poke you, that's technically battery under the law. So we think about that. It's arguable that if you start an IV on someone who didn't give you permission, you've committed battery. Confidentiality. Generally speaking, what happens in the ambulance stays in the ambulance except for the purposes of care and training. There are some common law torts such as false light or invasion of privacy. People have a right to their privacy. You don't invade it. Slander and libel, that's when you say bad things about people, whether spoken or written. There are state statutes, and there are federal statutes. The big one that everyone hears about is HIPAA. But there's over 50 state and federal laws related to patient confidentiality. All right, HIPAA, everyone's favorite topic. It's the Health Insurance Portability and Accountability Act of 1996. It's 2 A's, not 2 P's. I always say think aardvark, not hippo. HIPAA was originally designed as a way to facilitate electronic exchange of health information. It also protects the privacy and security of health information. It applies to covered entities. Healthcare providers that electronically bill for services, that's pretty much everyone these days, because at some point that bill gets electronically submitted to insurance or Medicare or Medicaid, health plans, and healthcare clearinghouses. There's a HIPAA security rule. It requires covered entities, and that probably includes EMS, to apply administrative, physical, and technical safeguards that reasonably and appropriately protect the confidentiality, integrity, and availability of electronic protected health information that they create, receive, maintain, or transmit. So administrative safeguard. Only the billing manager can get into the reports once they're submitted. That would be an administrative safeguard. Physical. The records are locked in that room that only the building manager has the keys to. Or technical. Well, it's all on the server and only certain people have password access to that part of the server. PHI. Down here, PHI is also a flight service, but PHI is protected health information. It's information that could identifies or reasonably could be used to identify the patient. It relates to the past, present, or future health or condition of their patient, payment for care or provision of care, and it's created or received by a covered entity, provider, or employer. Basically, if you know anything about HIPAA now, you need to know that PHI has to be protected. It includes medical information, billing information, their demographics, information stored electronically, information you convey on the phone, information maintained on paper. When can you disclose PHI? You can use and disclose PHI for your own treatment, payment, and healthcare operations, including QA and QI programs. You can disclose PHI for the treatment or payment activities of another covered entity, when it's legally requested by law enforcement, when it's subpoenaed, or when the patient signs an information release form. Who here has ever done a transfer from a nursing home? Do I have any volunteers? Do I have any volunteers? Am I talking to an empty room?
I have transferred to a nursing home.
Transferred from a nursing home. Brandon, did you get that sealed envelope from the charge nurse?
Most times, yeah.
You get that big sealed envelope, and they say, you can't look in it, it's HIPAA. Have you heard that line before?
I have, and then I usually violate it, and I look inside.
Absolutely. Why? Because you're part of that patient's chain of healthcare. And I joke right now that's why everyone in EMS should carry a knife in their cargo pants, so that you could take a knife and cut that big legal envelope open and see what's in there, because you may need to know that, because invariably that's where they hide the DNR. Any person who violates HIPAA is subject to a civil penalty of not more than $100 for each violation. The total in a calendar year cannot exceed $25,000 placed on you, and there are criminal charges for HIPAA violation of up to a $250,000 fine or 10 years in the federal prison if you did it with intent to sell, transfer, or use it for commercial advantage, personal gain, or malicious harm. There was actually a story out of Washington State a few years ago with a paramedic who did this. Paramedic worked for a private transfer service. All they did was transfers. He was their business development guy. He was the guy who was in charge of getting people who needed to go to the dialysis clinic and getting them signed up with his company. Well, he left Company A and went to Company B. When he left Company A, he took a flash drive with him that had all the contact information for all of the people that they transport from Company A. When he went to Company B, he called them and said, "Hey, this is Freddie, the paramedic who used to schedule all your transfers. I'm now over at Company B. Wouldn't you like to switch so that I can still take care of scheduling you?" He got federally charged and put in federal prison for that. Patient rights under HIPAA. You have a right to receive notice of privacy practices. At least every place I've been, or a lot of places I've been, we've got that stack of the little folded brochures that we throw at the patient's feet right as we leave the ER. They have a right to an accounting of certain disclosures of PHI. They can access or amend their information. They can request, doesn't mean we have to give it, but they can request a restriction on the use or disclosure of the information, and they can request confidential communications. Let's talk a little bit about evidence and crime scenes. Law enforcement should be notified whenever a crime scene is suspected. Emergency care of patients still remains our #1 priority. We need to disturb as little as possible. We observe and document anything unusual or that had to be moved to care for the patient, and we preserve the clothing as best as we can. On arrival, if law enforcement isn't there, whether it's the cops, the deputies, the troopers, whoever it is that comes when you need law enforcement, if they aren't there, you should size up the scene. Look for signs of forced entry. Are there open doors, broken windows, pry marks? Are the lights on or off? Any signs of violence where you're at? Flood, broken furniture, signs of a struggle. Listen for signs the perpetrator is still there. Smell for hazards. You know, meth labs have a smell to them. I can tell you a story about this. Years ago when I was working in Houston, we get called, and I was not the lead medic on the truck that night. I wish I had been, but that's a different story. We get called to a fall. It's at a really rundown apartment complex. We pull up to the door is partially open. We bang on the door. Paramedics, can we come in? Yeah, come on in, we're in the back. As we walk into the living room of the house, we notice there's a glass coffee table. The glass is completely shattered, like someone's been thrown on it. And as we look around, we see all sorts of funny white powder. That probably would have been a good time to leave, and I suggested that, but my partner's like, no, we're here. We'll take care of it. You need to preserve the crime scene. Show the police where you walked and try not to step in the blood or other liquids. We avoid cutting through holes that could have been created during a violent incident, so we cut along the seams if possible. Oh, sorry. We place paper bags over the hands to protect trace evidence because DNA may be under the hands and nails, and we never use plastic bags for clothing. I've been a EMT or paramedic for a little over 16 years. I have never, ever seen the paper bags on the ambulance to put stuff in. Just never seen it. If you remove clothing at the scene, leave it there. If you remove it en route, place each item in that separate paper bag, wrap it in a clean, or if not available, wrap it in a clean sheet. Leave it with the patient at the hospital, advise the ER what it is. If you move the patient before the police arrive, try to take a picture of the scene or note the position where the patient was found. Do not touch weapons or other objects unless required for personal safety. Something else I'll mention is if you have someone that you've tried to resuscitate, whether or not it's a violent crime or not, if you tried to resuscitate them and you pronounce on scene, leave the stuff you've used. Leave the endotracheal tube, leave the king tube in them, leave the pads, leave the IV, leave the IO needles. That may be part of the death investigation. Remember what you've touched and inform the police. If necessary to move the furniture, tell everyone what you did. If you forced entry, describe what you did. Don't touch phones in the house. You can tell some of this material was written years ago before everyone had a smartphone with them. Be prepared to give a statement to the police. They're probably going to log who all came in the room. And it's one of these things, if you've got someone who's obviously deceased, do both of you on the ambulance, your student, your field supervisor, and 4 guys from the engine company all need to go in there? Probably not. Make notes about the evidence as soon as possible, and in general, just work with law enforcement. Usually they're pretty easy to work with, and if they aren't, you just kind of work around it and you use your people skills. I've had times where the police, and in particular state troopers, not naming names, state troopers, want to conduct an entire field sobriety test of a traumatically injured patient from a car wreck. Hey guys, we need to get down the road. I'm in Texas. I'm in rural Texas. It's a little ways to the hospital. Statutory responsibilities. Every state has a medical practice act that basically says this is what the practice of medicine is and this is what a physician can do. So the physician has a responsibility to ensure our competency. Mandatory training. Most services have some sort of mandatory training. Skills competency, run reviews, chart review, whatever you want to call it. Medical director, each medical director liability, each state's laws kind of describe it, both for online medical direction. That's when you call the ER or receiving hospital and say, hey, I need your permission to do this. I'd like to talk to you about this. I need some guidance. And then there's also sometimes liability protection for offline medical direction. So the doctor who oversees your service but isn't necessarily the one providing online medical control, there's protection for him. There's also something called the borrowed servant doctrine that says that if you're supervising someone, you may be liable for their acts. So if you're a paramedic and you're supervising your basic partner and they do something wrong, you could potentially be liable. But we don't know for sure because every state has its own laws, and laws are incredibly dependent on the facts of the case. Every state has some sort of mandatory reporting laws. These are laws that require healthcare providers to report certain suspected situations, whether it's abuse of the children, the elderly, spouse, wounds obtained by violent crime, sexual assault. Some places also require dog bites to be reported. Healthcare providers can be held legally liable, as in criminally charged, for not reporting suspected abuse. In Texas, we're required to report knowledge of abuse of a child or elderly to either law enforcement or our state's family and protective services. And I can't speak for Pennsylvania, but down here we have a bunch of people who think that, well, if I tell the hospital, that's all I need to do. No, it isn't. You've got to report it still. Healthcare regulation. We've already talked about what scope of practice, that we don't have one. Pennsylvania does. Pennsylvania says, hey, this is what an EMT can do. This is what an advanced EMT can do. This is what a paramedic can do. And you can't go outside those lines. Every place licenses EMS. You have to have a license to be license or certification to be an EMT, advanced EMT, paramedic, whatever. If you're practicing without a license, you're practicing medicine without a license. In Texas, the Department of State Health Services regulates EMS mostly. I'm going to guess in Pennsylvania, I'm going to assume, which could be wrong, that you're certified by the Pennsylvania Department of Health. You also have certification. National Registry certifies someone, but it's not a governmental agency. Having a National Registry card does not give you permission to be an EMT or paramedic. Credentialing, a lot of systems have a requirement that you be credentialed by that department, by that system's medical director. Usually that's going through their FTO process. And then at that point, the medical director waves his magic wand over you and says, you are good to go. We're almost an hour in. Do you guys want or need a break? Rick?
Typically, I give them 15 minutes at this time, but that's completely up to you. Everybody's at home and has access to the facility, so it's completely up to you, Wes.
Would it be all right with y'all if I took 5 to go get me a bottle of water?
That is completely acceptable. Everybody